Good afternoon, friends and newcomers to our Friday special conversations with special people. I'm so happy to introduce our very special guest today, Judge Clarence Barry Austin, who will speak on the topic Overview of the Municipal Court System. Judge Barry Austin serves as the Chief Judge of the South Orange Municipal Court. He was appointed in 1994 and has served continuously since that time, with 26 years of continuous service. He is among the longest-serving municipal court judges currently sitting in the state of New Jersey. We're so lucky we have him. He also maintains a private law practice in South Orange, limited to the representation of personal injury matters on behalf of injured people. Judge Barry Austin is also active in the New Jersey legal community. He is a member of the American Bar Association, New Jersey State Bar Association, the Essex County Bar Association, and the Garden State Bar Association, the oldest and largest African-American bar association in New Jersey, where he served as a past president. But I must include what I think is the most important statement in his bio. With much to be grateful for and proud of, he considers his greatest blessing to his family, consisting of his beautiful wife, Carol, who I know, and she is beautiful and she's wonderful too, with whom he recently celebrated 42 years of marriage, his adult children, Carla, Tracy, and Brian, and his grandchildren, Macy, Kyle, and Jason, who bring him joy daily. That says so much about you. So now we all know and we think so highly of you. So please let us give a great big welcome to our very special guest, Judge Clarence Barry Austin.
Okay, thank you, Phyllis. What I'm experiencing on this end, and I don't know whether or not you're getting it on your end, but your audio is coming in and out. So even with your introduction, I got a couple of dead spots.
Oh, where was it?
Now, with my no worries about that. I'm just concerned that my audio is coming through consistently with everyone. So if I know most of you are on phones, but those of you who are on audio, if my audio is coming through inconsistently, or if I hit dead areas, just give me a high sign. Phyllis, I'm going to ask you especially, give me a high sign if in fact I'm hitting areas in which my image freezes or my audio is inconsistent, okay?
Of course.
All right. With that out the way, and with that having been said, let me thank you first of all for the opportunity to make this presentation to your guests and to your audience. I took a look at the people that have spoken to this group before, and the credentials of those individuals are truly spectacular. You have a former governor, you have a former assignment judge at the Superior Court, and I'm certainly in good company, and I'm honored to be among those invited individuals to speak to your group.
You're so well.
Thank you. So let me just start with a short story that I think will illustrate a point that I'm going to make. I'm going to circle back to later on in the proceeding. Now, when Phyllis first asked me to speak, I explained to her that as a sitting judge, I had to get a sign-off from my superiors to make sure that I'm not violating any of their principles or in any way making a presentation that would be unwelcome by my superiors. So I sent an email to my presiding judge, basically explaining to him, my presiding and assignment judges, basically explaining to them that I've been invited to speak before this group, and I'm seeking an opinion as to whether or not that would be problematic in any way. About a few days later, I got an email from the counsel for the committee that has oversight of judges and judicial personnel. It actually was about an 8-page memo, single-spaced, complete with analysis and citations that eventually indicated that they didn't see any problem with me speaking, but with the following caveats. I'm just going to read what he said. Judge Barry Austin should avoid controversial and political issues, should not comment on cases or proceedings pending in any court, should not express an opinion on any pending legislative reform, should not discuss his approach towards the resolution of legal issues, should not clarify, defend, or justify any of his decisions or opinions or reasoning therein, even in the absence of an appeal, should not discuss a legal topic from the point of view of any special interest group. Now, I start with that story only to, well, first of all, to just establish the guardrails that will contain our discussion going forward, but mostly to illustrate to you a point that, again, I'm going to talk about a little later on, that really indicates to you that you have a judiciary that is focused and is committed to the principle of avoiding even the appearance of impropriety. So again, I'll talk about that a little later on, because I think the core values of our judiciary is something that the public needs to be informed of, needs to be aware of, so that you have the judiciary has credibility, and it's one that that you can count on to be impartial, and one in which you can respect. So with that out the way, this is the way I plan to go forward, the outline that I plan to present to you. First of all, I want to talk a little bit about the structure of the judicial system and where the municipal court fits into that structure. Then I'll go into the movement of a case through the municipal court system. Then I'll touch on some individual topics that I think that may provide some interest and may be useful to you in your experience with the municipal court, if you should have the occasion to have a municipal court matter in the future. So first of all, now with regard to the structure of the court system, we have the Supreme Court of the state. And when you hear me refer to the Supreme Court, and then after I do all that, I hope to leave some time. And actually, I think I'm better in terms of responding to questions. So I want to leave some time so that we can have a robust conversation at the end with regard to any questions that you may have that may be related to the presentation that I'm giving to you, or maybe something outside of this discussion that you may have some interest in. Again, as long as it doesn't transgress on those areas that I mentioned that I've been cautioned about to stay away from. So again, with regard to the structure of the court system, we have the Supreme Court, which is the state Supreme Court. When I refer to the courts, I'm talking about the Supreme Court. I'm talking about the courts of the state of New Jersey. Understand that there is a federal system and there's a state system. I'm going to be talking exclusively today about the state system. So the highest court in our state system is the Supreme Court, and that's presided over by the Chief Justice of the state of New Jersey. Now, the Supreme Court is also the administrative head of the judiciary in the state. The administrative functions of the judiciary is handled by the administrative officers of the court, known to lawyers and judges as the AOC. And the AOC is under the umbrella of the state Supreme Court and is the highest judicial officer. There is the administrator of the courts, and he answers to the Supreme Court, again headed by the Chief Justice. Under the Supreme Court are our superior courts, and within the superior courts, we have the law division, we have the appellate division, we have the chancery division, and we have tax courts. And we won't be talking about chancery and the tax courts, but I mentioned those only to point out that the law division and the chancery division and the tax division are trial courts. They're initial cases where there are the courts where cases start. The appellate division of the Superior Court is the first level of appeals of our state court system. Again, the Supreme Court being the highest level. So a case would go from the trial level to the appellate division and then into the Superior Court. The Superior Courts are of statewide jurisdiction. Their judges are appointed by the governor and approved by the Senate. Those judges serve for 7 years. Tenure is provided to age 70 if they are reappointed after 7 years. Now, the municipal division serves below that, in that those are courts that we call of limited jurisdiction. They're limited in terms of geography, they're limited in terms of subject matter, and they're limited as to the individuals that are subject to their jurisdiction. limited as to the geography. That's referred to as territorial jurisdiction. So the municipal courts sit in individual municipality. And as a general rule, and I should also just add as a caveat, when I'm speaking today, I'm speaking in generalities. The law exceptions are inherent in any discussion of the law. If we spend time talking about the exceptions, it would probably not get us off of topic one, because just about every rule or principle, there is at least one exception. So in many instances, in many of the rules that we have, the exceptions in large measure swallow the rule. So I'll be speaking in generalities. So just bear with me and consider that as we go through this, this outline. So we talked about geography. As a general rule, each municipality has a municipal court. Now, that's a general rule. There are some municipalities that share a court, but for the most part, the municipal courts sit in an individual municipality, and they have jurisdiction over those events and those matters or those activities that occur within the municipal boundaries. With regard to persons, we only have jurisdiction over adults. Only in limited instances can we impose jurisdiction over juveniles. So for the most part, our what's called in personam jurisdiction extends only to adults. So you have jurisdiction over matters that occur within the borders of a municipality, and you have jurisdiction over adults that commit offenses that exist within those jurisdictions. Then you have what we call subject matter jurisdiction. We adjudicate matters involving traffic offenses, which includes DWIs, minor criminal matters, including things like shoplifting, simple assaults, minor drug offenses, domestic violence, TROs. And TROs are temporary restraining orders. So from time to time, I'll be awakened in the middle of the night with someone applying at the police department for a restraining order alleging a act of domestic violence. We're also empowered to temporarily remove weapons from individuals considered to be dangerous to themselves or to others. Now, those are temporary orders that we enter. And with the temporary order, what we would also provide is a date when they can report to the Superior Court and have their matters heard by a Superior Court judge, who would then determine whether or not an order of more permanent duration would be appropriate. We also administer and adjudicate ordinance violations. Ordinances are those matters or those laws that have been passed by the local jurisdiction, the local municipalities. So those are matters, those are subject matter jurisdiction. Those are the subject matters within which or upon which we can exercise authority or jurisdiction. The maximum time, the maximum jail time a municipal court judge can impose is 6 months. The maximum fine the municipal court judge can impose is $1,000. Now, I had mentioned that Superior Court judges are appointed for 7 years with tenure to age 70 if they are reappointed after 7 years. The judges in municipal court serve for 3-year terms, and they have to be reappointed at the conclusion of each 3-year duration. They're appointed by the municipal. Now, I would also mention, in comparison, the Superior Court judges are appointed by the judge, by the governor, and appointed and approved by the Senate. The municipal court judges are appointed by either, depending upon the municipality, it may be by the highest municipal officer, which would be the mayor, or by the board, the governing board of the municipality. As in South Orange, our board of trustees is my appointing authority. So we are appointed for 3-year terms. So every 3 years I have to be appointed in order for me to continue to be the judge of South Orange. Now, with that having been said, let me just point out that it's been recognized that although we are courts of limited jurisdiction, we are viewed as the most important court in the judicial system. And that's because that's the court where most people are aware of. That's where most people come in contact with the judiciary. That is the experience in the municipal court, is the experience that usually informs most persons' experience, or their perception, I should say. The perception of the judiciary is often formed by the experience they receive in the municipal courts. So the judiciary is very aware, the state judiciary, the Supreme Court, the Chief Justice is very well aware that that's the reality, that most people come in contact with the judiciary at the municipal court level. And so therefore we are considered to be, for that reason, we're considered to be the most important court in the system. That having been said, a lot of resources are provided to the municipal courts. We're provided with a professional manager. All municipal courts are staffed by judges and a professional management staff. So we have a court administrator who is a licensed individual who has to pass an exam, who has to be vetted by the municipal court administration before they are empowered to sit in the capacity as the municipal court administrator. So that is an overview of the structure of the judicial system and where the municipal courts sit within that structure. Now, with regard to the movement of a case through the system, it usually starts with the issuance of a summons and complaint. And you can think of that in most instances as a traffic ticket. You get a traffic ticket by a police officer issuing for a perceived violation that occurs on the road, a violation of a motor vehicle, some motor vehicle violation that results in being stopped and a ticket issued. The ticket is the complaint. It also summons the individual to respond to that ticket by either pleading guilty, and there's a procedure on the ticket for pleading guilty, and there is also a procedure on the ticket for pleading not guilty. There is also a date when the person, if they're going to be pleading not guilty, would have to respond to the court in order to answer the charge that is represented by that ticket. Now, again, most tickets can be dealt with by simply pleading guilty and paying the fine indicated on the ticket. So you pay the fine, you indicate on the ticket that you're guilty, you send the fine in, and that's the end of it. Some violations, however, do require a court appearance, and those tend to be violations that have what we call enhanced penalties. Enhanced penalties are penalties that vary based upon the number of prior times that the individual has either pled guilty or has been found guilty. Those require an appearance in court. Could you give me a drink of water? Those require an appearance in court. Now, for those people who are pleading not guilty, they would appear in court on the designated day for a first appearance. When you come to court for a first appearance, that's before the court starts hearing cases, what's called an opening statement is presented. The opening statement provides the individuals assembled with their rights in court, and that would include things like the right of counsel, right to counsel. Thank you. Excuse me. So the right to counsel, the right to trial, the right to an interpreter, and also provides for the procedures that the court operates under, so that some of the mystery is taken out of process, so that people understand how they can go through and traverse the different procedures of the court. So that's prior to the court calling an individual case and asking the person to enter a plea. Now, remember, the fact that they're in court means that they would have initially entered a not guilty plea. So they would have gotten the ticket, they would indicated not guilty, send the ticket in, responded by the date that is indicated on the ticket. And now, after the opening statement is presented to them, they would then be called to formally enter a plea in open court before the judge and on the record. So at that point, they still have the opportunity to change their plea and enter a guilty plea, in which case the matter would be disposed of in a summary manner. And we can only accept a guilty plea if they are in fact going to acknowledge that they committed the offense that they are pleading guilty to. And once I'm satisfied that that's a legitimate guilty plea, it's authentic, I will then accept that guilty plea on the record, and then I would impose a penalty. They would pay the penalty and they'd be on the way. Now, to the extent that somebody's going to be pleading not guilty, we would give them a trial date. At that point, we would indicate to them that they're going to be coming back. The case would be tried on its merits. Now, understand that in municipal court, all cases are tried before judges. They are not tried with juries. That's one of the distinguishing factors from the Superior Court. Superior Court provides for jury trials. The municipal court provide for non-jury trials. All cases in municipal court that are being tried to the judge. So they'll be given a date when they would return to court and when the case would be tried. Now, if at that trial, and they'll also be given the opportunity, if they cannot afford an attorney, to apply for a public defender. So when they return for trial, if at that trial, after hearing the facts, the judge concludes that the facts indicate to him or to her that the burden of proof of the prosecution, now the state has to prove the elements of the offense or offenses beyond a reasonable doubt. If the judge is persuaded that the prosecutor has satisfied that burden, met that burden, the person would be declared guilty, and then a sentence would be imposed. If the judge feels that the prosecutor has failed to persuade him or her to beyond a reasonable doubt that in fact the defendant has violated the designated beyond a reasonable doubt, then the person is declared not guilty and they can be on their way. But assuming a guilty plea, a sentence would be imposed, and then the person would be informed that they have a right to appeal and they can appeal within 20 days. So that would be in a nutshell, in a very accelerated way, would be the process from ticket to disposition at trial. Now, I've discussed the municipal court procedure basically in the context of a traffic ticket, but those minor criminal offenses that I discussed earlier can be brought by citizens. For the most part, traffic tickets are brought by police officers, or you can get a ticket by a parking authority officer if those would be parking tickets. You see them going through town, specifically in South Orange. You can see the parking authority individuals going to the parking lots to determine whether or not people have overstayed the payment on the parking meter. So there's a parking authority in town, and tickets, moving violations for the most part, would be issued by police officers, that you get stopped on the road by a police officer. But the minor criminal matter, shoplifting, for example, or some minor drug offenses, or the DWI offenses that I talked about, those are issued by police officers, but they can be issued also by individuals. So sometimes we get matters in court that are neighbor disputes. So neighbor has a problem with their neighbor, they come to the municipal court, or they come to the police station, they say they want to file a complaint against their neighbor for a particular perceived violation. And that charging document, much like the traffic ticket, is what initiates the process and starts its traffic I don't want to use traffic in that sense, but starts progress through the system that I just described. And it follows each of the steps that I just described in a very general way to the point where there is a disposition on the record by the municipal court judge. So let me talk about plea bargaining, or plea agreements, I like to call them. I don't like to call them plea bargaining. The court recognizes plea agreements. That's the nomenclature that we use. And people are sometimes confused, or plea agreement process sometimes is a disparaged process, but in fact, it's an integral part of our municipal court proceedings and our municipal court system, as really even in the Superior Court, plea bargaining is employed to a large degree. And it's employed to a large degree because it's the only way in which the court can handle the volume of activity that it is empowered to handle. With regard to the municipal court, millions of cases go through the municipal courts. Each year, millions of cases, and there's no way that the court could adjudicate and administer that volume of activity unless we employed a process of a procedure of plea bargaining, or plea agreements, as I say, I like to use. And for those of those who aren't familiar, a plea agreement occurs when the prosecutor and the defendant agree that in exchange for example, the prosecutor would present to a defendant, you got 3 tickets. So in exchange for a guilty plea to ticket A, I will recommend to the judge that he dismiss ticket B, or big ticket C, or ticket B and C. Or that you'll plead guilty to all 3, but I won't make a recommendation of sentencing to the judge. Or for in exchange for a guilty plea to ticket A, I'll reduce the charge on tickets B and ticket C. So it's an agreement that will allow for the adjudication of the entire matter, or matters that bring individuals to court, in a fashion that satisfies the system and also satisfies the defendant. Now, I don't want this to sound like it's a barter market, because the only kind of pleas that we can accept are pleas in which individuals acknowledge that they have committed the offense that they are pleading guilty to. So it's not as if the prosecutor's presenting to an individual a completely collateral and unrelated matter in order to promote a plea agreement. No, it's got to be a matter that someone will acknowledge. It's usually, but not necessarily so, that it is what we call an included offense. It's an offense that the person can acknowledge that in fact they did plead guilty to. So for example, if a person is charged with going 20 miles over the speed limit, and they say, well, I wasn't going 20 miles over the limit. I'll admit that maybe I was going 5 miles over the speed limit, and I'll be willing to plead guilty to that. So that's an example. The person is not pleading guilty to something that they just adamantly say that they did not commit, but they're willing to say, well, yes, I did. I will say I'll go 5 miles over the speed limit. So the prosecutor would recommend to the court that the amount of speed over, and it requires, it involves a lesser fine. So the court may very well say, the prosecutor may say, well, I'll recommend to the court that you accept a plea going 5 miles over the speed limit instead of 20 miles over the speed limit. So that's a very simplistic kind of explanation, but I just want to make clear, when we talk about plea agreements, it's not something where someone is coerced into pleading guilty to something that they adamantly say that they did not do, but it's something that they have to acknowledge that they in fact did do. Now, many people are confused about the plea bargain process, in that when they come to court, they're basically trying to avoid points on their ticket, and they are, and that's generally the prime motivation, points on their ticket, points on their license, I should say. So many, or they want to avoid the inconvenience of coming back to court, and that may be their single motivation. And I've got to explain to them that I can't accept a guilty plea only as a matter of convenience. You have to acknowledge that you've committed the offense that you are attempting to plead guilty to. In addition to that, it may be a convenience to you in that you can dispose of the matter today and you don't have to come back, or you have a ticket, you're pleading guilty to something that won't result in points on your license. But in addition to that, you have to acknowledge that you have committed the offense. So many times I can't accept a guilty plea because someone will say, well, Judge, I just don't want to come back. I didn't do it, but I don't want to come back. But once you say that, you take away my ability to accept that guilty plea. Because again, the courts are not courts of bargaining or bartering justice. We only impose penalties upon people who we find guilty of offenses, and either that guilty status has to be proven at trial, or it has to be acknowledged by the individual. So the underpinnings of the plea agreement process is, in fact, that the person would be acknowledging that they have committed an offense, and they're satisfied that they indeed are guilty of that offense. Now, sometimes some people say, well, that's what the police officer said that I did. Well, that's not enough. If you're pleading guilty, you've got to be pleading guilty to something that you have a consciousness of fault, that you have a consciousness of guilt. So with those things in place, once I'm satisfied that the person is giving me that's called getting a factual basis. Once I'm satisfied that they have provided an adequate factual basis and they've waived all their rights, they have to understand too, before I accept the plea on the record, that they do have a right to go to trial and make the prosecutor prove the matter beyond a reasonable doubt. Sometimes people say, well, Judge, is my word against his? It's a fixed system. Well, again, that's why we want to make sure that the system is transparent. It's not a fixed system. The state has to prove, you don't have to disprove anything. The state has to prove that you in fact committed the offense, and the judge has to be satisfied and persuaded beyond a reasonable doubt. So if somebody says to me, I'm pleading guilty because it's my word against his, and I know you're going to accept his word, I've got to disavow them of that idea and let them know that the state has to prove them guilty. They don't have to prove themselves innocent. So once they understand that they have a right to go to trial, they have a right to an attorney on certain cases, and in certain matters, if they can't afford an attorney, they can be provided with a public defender. And they acknowledge all of those things and they're willing to waive those rights, I would then accept the guilty plea on the record, and then I would proceed to impose a sentence. Now, with regard again to the prosecutor presenting a plea proposal, remember I said that the prosecutor would recommend a certain disposition. The prosecutor will present to the court, the judge in open court, that this is the plea arrangement that I have with the defendant, Your Honor, and the court would then decide. The prosecutor only recommends. The judge can then accept or deny that recommendation. And some of the reasons why the judge may deny their recommendation is because it's not in the interest of justice, or it's inconsistent with the intention of the legislature, or it's inconsistent with court guidelines. I should mention that the plea arrangement is not without its limitation. The court has indicated, the Supreme Court has indicated that we are precluded from taking plea arrangements in DWI matters and in some drug matters. So it's an expression of the seriousness with which the court views DWI and drug matters. It's a reflection of the seriousness with which they view those matters that the court has imposed a strict prohibition to any plea arrangements or plea agreements in the area of DWI or drug offenses. Excuse me. Now, everything I've just discussed in terms of the in-court procedure and proceedings For the most part, preceded COVID, preceded the court shutdown. Now, everything that I've described with regard to in-court proceedings is handled online virtually. So if the person enters a not guilty plea, or if they have one of those tickets that require a court appearance, they are going to be appearing virtually, much as we are having this conversation virtually. The platform that the municipal court in South Orange uses is Zoom. Some courts use Microsoft Teams, and I believe there are some other online platforms that are used in some other courts. But South Orange, Maplewood uses Zoom. So what happens is, at the time that the ticket is issued, again, using the example of traffic tickets, at the time that those tickets are issued, they'd also be provided with a notice and information with regard to how to connect with the court. And it's usually by way of a phone call, so that they would then understand the procedures that are expected, the procedures that will be employed in moving their matter through the court. So they're generally informed to call in at a designated date and time. And they would then, as I mentioned, the opening statement, which is a mandatory procedure in all courts, because it's important that the people assembled at least have a general idea of, first of all, what their rights are, and also what the procedures of that court would be. So they would sit through. In my situation, I don't get on the line. I don't get into the court session or call in until I'm certain that everybody has sat through the opening statement. I won't proceed with anybody's matter until I'm satisfied that they have in fact sat through the opening statement. Now, with regard to, we can dispose of matters in which people are pleading guilty in the same fashion that I described before. So it would simply be a matter of doing it online in a Zoom session. And if you're pleading guilty, I accept the guilty plea using the procedures that I mentioned earlier. And the people would then be told, if they're, once the sentence is imposed, the fine is imposed, they'll get an email from our court advising them how they should make payment, and any kind of payment arrangements that they want to engage in. They can discuss that when they call in. If it's something that needs my review, my court administrator or court personnel will get in touch with me, and they'll have my input at that point. But with regard to not guilties, those people who are still maintaining a not guilty plea, we have to but the courts have not yet developed a court trial procedure. This is something under investigation by the Supreme Court and the administrative office of the court that I mentioned before. They have not yet finalized a procedure, a safe procedure that would allow for the disposition of contested matters, litigated matters, or trials in municipal court. So those matters are basically being held in abeyance until such time as we get direction from the Supreme Court as to how we are to proceed with those matters. All right, so that's the movement, in a general sense, the movement of a matter through the court system, the plea bargaining process being a part of that, the process of the progress of a case through the municipal court. So let me just touch on a few collateral issues that may be of interest and may be useful to some people. What's this about part-time judges? Because many people don't understand the concept of part-time judges. Many times when people come into my office for a legal matter, in my legal office for a matter, and they find out or they know that I'm a judge, they're puzzled as to how are you? I thought you were a judge. Or if they know I'm a judge and they find out I have a part-time or I have a legal practice, which is not a part-time legal practice. It's in every sense a matter of full-time legal practice. But it puzzles, it confuses people. So let me just explain that the judges on the Superior Court are full-time judges. The judges on the municipal bench, for the most part, are part-time, and they serve consistent with the time needed to dispose of the cases generated in that municipality. So although some municipal court judges sit full-time, most municipal court judges sit part-time and do have private practices. The restriction on judges in their private practice is that we cannot practice criminal law. Now, those judges on the municipal bench that sit full-time generally would include the larger municipalities, things like Newark, Patterson, Trenton, or Camden. Those judges sit full-time, but for the most part, the judges on the municipal bench are part-time judges. The judge in South Orange certainly is. You know that from the bio that Phyllis gave you in the beginning, mentioned that I do have a private practice. Also, the judge that sits in Maplewood, in the court building that we share, he also serves part-time and has a private practice. Now, I want to circle back, and I'm mindful, well, actually, I want to leave some time. I'm going to just touch on a couple of these that I think it's important, but I see that time is running. I do want to leave some time for questions. But I wanted to emphasize I wanted to sort of circle back to the reason I told you that story at the beginning. And because it illustrates the core values of our judiciary. And I wanted to leave you with the idea, the sense and the confidence that you have a judiciary that is committed to the idea of individual justice in individual cases. It's a judicial system that is committed to rendering fair and impartial justice. It emphasizes equal treatment for individuals, regardless of wealth, regardless of position, regardless of age, regardless of gender. We want to provide a judiciary. I want to convince you, persuade you, leave with you the idea that this is a judiciary that truly is committed to rendering fair and impartial justice. It's one in which even the appearance of impropriety is unacceptable. So if in our judgment as a judge, there is a circumstance that could shed some shading or some improper light on any of our activities, then we have to avoid that particular circumstance. And that is the reason why we have to get some kind of sign off when we make an appearance publicly, because in the eyes of the judiciary and also in the eyes of the public, when we appear, whether in our private capacities or in our public judicial capacities, we are representing the judiciary. And when a judge, even in a private capacity, does something, it can shed a negative light on the judiciary, and the Supreme Court is very well aware of that, and they are committed to avoiding even the appearance of impropriety. It's also, the Supreme Court is also committed to provide an informed bench, a bench that with confidence can state the law and have it be received as coming from a source of authority. So in keeping with that principle and that core values, the judges in the state, municipal and superior court judges, are provided with frequent and continuous mandatory training. Also, a core value of the judiciary is to ensure that the public is treated with dignity and respect. I always say, I expect you to treat the robe, the institution of the judiciary with respect, but I understand and recognize that I have to also treat you with respect. We're charged with having a temperament that does not shed a negative light on the judiciary. I'm always amused when I see the judges on TV. I think part of their appeal is the fact that they can disparage and shout and insult the people before them. In New Jersey, if we did that, we would be subject to a complaint. And I can promise you, you make a complaint about a judge, it will be investigated. So, and that's also a part of the emphasis, is a part of the commitment that the Supreme Court has to our judiciary, that they want to provide a judiciary that is free from stain whatsoever. Also a judiciary that is free from political influence. So we're not permitted in any way to engage in political activities, or we have to be very mindful with regard to our political affiliations in terms of appearing publicly with politicians and things like that. Those are things that we are not permitted. And finally, before I open it to questions, I just want to also talk about the fact that one of the core values of the judiciary is promoting the full transparency of the process, so that everything that we do has to be done in open court. When we make decisions, we have to explain our decisions. So I talked about the process of entering a guilty plea. I'm sorry, not entering a guilty plea, but entering a guilty finding, or even a not guilty finding. When we hear cases, before we render the decision guilty or not guilty, we have to recite into the record the facts upon which our conclusion is based. So the process itself is a transparent process. It's one that's open completely to the public. So all our proceedings are public proceedings. We don't do anything in private. Even if things occur in chambers, we have to now come back out onto the bench and read it into the record, so that there's a record that's available for all to see. There's a couple other points I wanted to touch on, but I see that the clock is ticking, and I did want to leave some time for questions. I apologize if I went over the time that, but I hope that we can have a little conversation and perhaps answer some questions that you may have. Thank you.
Oh, thank you. You were so informative and fascinating. I have a question about the drug problem. Now they're opening up the prisons. Now, does the judge have any saying about who will be released and because of the COVID?
Yeah, no, that would be a decision that's outside the purview of any individual judge. Those are decisions that are made. I'm not sure at what level. I just know that that's not a decision that would ever come before me as to who would be released. It certainly would not be a decision made by the municipal court judge. Those decisions tend to be made at the highest levels of the judiciary. That would be the Supreme Court level. They would determine the guidelines that would dictate what individuals are released from jail. Or it may be at the legislature. I can't speak with authority about that. The only thing with authority I can say is that's not something that a municipal court judge would be involved with.
Thank you for answering it. Because I know you said you deal with the drug people who have drug problems.
No, well, that would be at the level where a charge has been made and the matter is before the municipal court judge to decide. So, with regard to the drug matters, I mentioned in the context that we can't plea bargain certain drug offenses. Those are not offenses that are subject to the plea agreement that I described. Also, some cases have to be tried, and if they're within the jurisdiction of the municipal court, those drug offenses, like possession of minor quantities of marijuana, they would come before the municipal court for adjudication. But once the decision is made, it's outside of our jurisdiction. I mean, the sentence is imposed, then it becomes a matter for, if the person wants to challenge that determination, then they would have to appeal to the Superior Court.
Thank you.
I have a question.
If you could identify yourself so I know who I'm talking to.
This is Tracy.
Oh, hi, Tracy. How are you? Good.
Hi, Clarence. How are you? With regard to, I'm going to say petty crime, perhaps shoplifting, things of that nature, that are committed by like youth in town. I know that Maplewood has a restorative justice program, and I don't think South Orange has a program like that. So do you actually hear those kinds of cases with regard to youth and what I equate to really bad decisions made by young people because they're not really that smart yet? Do they come to your court or to a different court?
context of in personam jurisdiction, and I mentioned that only in limited instances are matters involving juveniles before me. So the municipal court judges would not hear a case involving a juvenile committing that kind of offense. Those tend to be, there's a separate system for dealing with juveniles, and it's not through the court system as I've been describing it. So those matters generally would be held as a juvenile justice matter, and I really am not that familiar with the juvenile justice procedures, but those matters, a juvenile committing a petty offense or disorderly person's offense, we characterize them, would not come before a municipal court judge.
Okay. Do we actually track different types of cases on a municipal basis? It's Tracy again. On a municipal basis, and what kind of statistics does the township actually track, record, and track on a regular basis regarding our court system?
In terms of what matters?
With regard to any kind of matters, I guess there are things that relate to like process and production, like from the time in which a person is actually issued a ticket or a summons of some sort, and how long it takes them to actually get a court date, how long it takes to close a case. I mean, do we actually have statistics around municipal court system that the township tracks itself?
Well, I don't know. Well, let me say this. If you want statistics, we got statistics, all right? I can't recite those statistics to you, but I can get them to you. Now, that's one of the things that I mentioned, is that we have a very professional municipal court administration and a superior court administration. So, and this, I mentioned the administrative officers of the courts. Now, they keep all kinds of statistics. Statistics, we are measured against statistics on a monthly basis as well. Now, I can't cite those to you. In the time that I have left, I wanted to also just commend to you that you do have a municipal court administration that you can be well proud of. We've got a very professional staff. We've got a remarkable court administrator, and anytime that I get compliments on the performance of our courts, I always make sure that I mention that I'm only the face of the court to the public, but in fact, behind the scenes, we have a very, very professional and a very experienced administration that's handling matters in the court. So if any kind of information like that you would need, I would recommend that you contact the court, ask to speak with the court administrator, and he can provide you with any information that you need. But they keep statistics galore, I promise you.
Now, is the administrator a professional, a legal professional, or just an administrator?
Well, I wouldn't characterize him as just an administrator. That's a tremendous job. He's not a lawyer, but he's an administrator. So he's got administrative experience. He's got administrative training, he and his staff are truly the ones that make the court run. I mean, they make me look good, in other words. And I always defer to them in terms of any kind of positive feedback we get about the courts. I always make sure to mention that really we have a remarkable administrative functioning down at the municipal level.
They're very fortunate in having you. So, and we are too. I'm afraid we're going to have to end it. The library opens at 2:00, and we're multitasking as usual.
Can I ask a question, please?
The last question.
Yeah. I was wondering, in your private practice, do you present cases to judges that you know? Are they your colleagues? Are they people that would be in your circles? Or do you have a special people that you represent? Or do you take any municipal case before a court?
Okay. First of all, I mentioned that municipal court judges cannot take in their private practice criminal matters. So no, and we're precluded from appearing to any extent in a municipal court. So my practice does not take me to municipal court at all. Now, with regard to appearing before judges that I know, I've been practicing over 40 years. I practice in Superior Court. My practice is a civil practice. It's not criminal at all. And in the course of the 40 years, I do appear and have appeared before judges that I know and know me. It's inevitable, with that kind of time in the system, you know people. Also, many of the judges that appear before me practiced with me when they were lawyers. So yeah, and the civil bar, or the civil bench, is not that extensive that with the number of civil cases that are heard. And I tend to practice basically in Essex County, Union County, limited way in Hudson County. So yeah, I do appear before judges who I know and who know me.
Okay.
But not in municipal court, never in municipal court.
Thank you so much, Judge. You were fabulous and fascinating, and I appreciate the time that you have given us.
Well, I certainly appreciate the invitation, and it's been a lot of fun.
And say hi to Carol. I haven't seen her. Say
Okay. She's right here if you want to say hello to her.
hello, Carol. Hi, honey. Don't worry, I'll renew your books.
Hi, Carol.
Yes.
Okay. Have a great weekend, all of you. Be safe and be healthy and happy. And I hope that you'll join us next Friday. Take care.
Yeah.